Let's take a look at good faith bargaining. The law does not and cannot ensure that collective bargaining will result in an agreement. However, good faith bargaining is required. The NLRA does not go very far in defining what this means. It refers to the obligation to confer in good faith with respect to wages, hours, and other terms and conditions of employment. There is a mutual obligation of the employer and the representative of employees to meet at reasonable times and to execute a written contract incorporating any agreement reached. Because parties to a collective bargaining relationship are free to engage in hard bargaining and need not reach agreement or even make concessions to the other party, identifying when there's a lack of good faith is difficult. However, actions such as imposing conditions on the holding of negotiations, inhibiting or delaying negotiations, withdrawing accepted offers, are indicators of a lack of good faith and should be avoided. Good faith bargaining entails sharing information. As a general matter, employers are required to supply unions with requested information that is relevant and necessary to representing employees effectively. This information is usually limited to wage and other employment data directly related to bargaining issues rather than financial data. However, if an employer asserts that a union demand cannot be met because of financial constraints, the employer will have to provide financial information if it's requested to substantiate the claim. Bypassing union representatives and appealing directly to employees constitutes refusal to bargain with the legal representative of employees. Employers also fail to show good faith when they make material changes in employees' terms and conditions of employment without informing and negotiating with unions over these changes. The duty to bargain pertains to wages, hours, and terms and conditions of employment. This phrase is given broad reading under the NLRA, but it does have some boundaries. The NLRB distinguishes between mandatory and permissive or voluntary topics of bargaining. A mandatory topic is an issue that, if raised by either party, must be negotiated over. Furthermore, disagreement over a mandatory topic is a sufficient reason for failing to reach agreement in negotiation. By contrast, if a permissive topic is raised, the other party can decline to discuss it. Moreover, if a permissive topic is discussed but not agreed on, it cannot be the basis for failing to come to terms. The many mandatory topics of bargaining include wages, bonuses, benefits, work schedules, safety, layoff and recall procedures, and grievance procedures, to cite only a few. Permissive topics are all non-mandatory topics that are not illegal to incorporate into a labor agreement.